Good morning. Now, I've been asked to speak about the implications of the Act from the point of view of a practitioner, and that includes solicitors, advisors and lay representatives. What I would stress at the outset, though, is that this is a new procedure for everyone involved. It's not something which solicitors have had the chance to practice in, and it's being extended to lay representatives. It is a completely new procedure for everybody, so there are still a lot of uncertainties as to how things are going to work in practice. Now, what the Act actually does is to amend the 1970 and the 1894 Acts. These are the two acts which regulate the enforcement and calling up of standard securities at the moment. The 1970 Act is by far the most common, but you will still see some cases where lenders found on the 1894 Act. Now, the Act applies to all standard securities over residential properties, so that's quite an important change. The Mortgage Rights Act, those of you who are familiar with mortgage rights cases will be aware that you can only lodge a mortgage rights minute in respect of your sole or main residence. There's no longer that qualification in the new Act. It applies to all residential properties. It doesn't apply to commercial property unless the commercial property is used for residential purposes to some extent. So if your client has a business property and the security over that property is being called up, then this Act won't apply. However, if they've got a shop with a flat above it and the security is over the entire property, then this Act will apply and the lender will have to raise a court action under the new procedure. Now, the first main change is that the lender must raise a court action to enforce the standard security. At the moment, a lender doesn't have to do that. What they can do is serve a calling up notice. They wait 2 months, which is the period of the calling up notice, and then at the end of that period, if the property becomes unoccupied at any time within the next 5 years, the lender is entitled to take possession of and sell the house on the basis of the expired calling up notice. So they will no longer be able to do that. The only exception to raising a court action is voluntary surrender. There are provisions within the Act for a client to be able to voluntarily surrender their property. There are quite stringent measures which have to be met, though, for that to be done. The Act provides that the relevant parties must give written certification that they agree to the voluntary surrender, and they have to certify a number of factors. Now, the first factor is that they have to confirm they don't occupy the property and that they're not aware of anyone else occupying the property. So voluntary surrender can't be done where your client is still in the property. It must already be unoccupied before that can be done. They have to confirm in writing that they consent to the creditor exercising their rights on default of the standard security. And they also have to confirm in writing that their consent is being given freely. Now, it's not just the borrower who has to give that certification. The Act provides that all relevant parties must give that certification. So that would include, for example, a non-entitled spouse if the property is a matrimonial home, or if there is a civil partner, if the property is a family home, then those people have to give that certification as well. The main point to make about voluntary surrender is that there is no provision to reverse it. It does appear to be irreversible and the final step. There's no cooling off period and there's no way of going back once your client has given the certification which is required by the lender. Now, the action, if one is raised, is done by summary application, which is a sort of shortened version of the full ordinary cause procedure in the Sheriff Court. It's not summary cause, so it's different from heritable cases, which some advisors may already be dealing with. It is a different type of procedure. There are summary application rules which regulate summary application procedures. So anybody who's going to be advising or representing in this area should familiarise themselves with those rules. They can be accessed on the court website, and the rules have been amended to take into account the new legislation. Now, when a lender raises an action, they lodge an initial writ at court. There's a style of the initial writ in the summary application rules, but it's pretty much identical to the initial writ you will see in repossession cases at the moment. As well as lodging the initial writ, the lender has to lodge a Form 11C, and that's the form where they certify that they've complied with the pre-action requirements. It's a pre-printed form, and what they have to do is go through it and tick the boxes, but for certain of the pre-action requirements, they then have to provide details of how they've complied with those requirements. and if necessary they have to produce evidence. It's not enough for them simply to tick the box and say that they've complied with it. Now, we've spoken about the pre-action requirements, so I'll go over them quickly and perhaps just make some points from the point of view of what a practitioner should be looking out for. The first pre-action requirement is that the lender has to have provided clear information about the terms of the security, the amount due, the arrears and charges. That has to be provided as soon as reasonably practicable after the default has taken place. So when you see your Form 11C, and the forms and rules have all been finalised, so by all means have a look at them and familiarise yourself with the forms. When you see the Form 11C, that box will be ticked, and then underneath it the lender has to complete details of how and when they complied with those requirements, or with that particular requirement, when the information was given, and they have to produce copy correspondence if appropriate. So the way we're looking at it is the Form 11C is probably going to be more important than your initial writ, because the initial writ is going to be fairly basic, but the Form 11C is where you're going to get all the details about what the lender says about the pre-action requirements. So that's what you're really going to have to look at and go over with your client and get instructions on that form. Now, the next requirement is that the lender has to have made reasonable efforts to agree proposals, and again they have to tick that box and then provide details of how they made those reasonable efforts. So for example, they would have to say what negotiations took place, what proposals were made, whether any proposals were made by the borrower and were rejected by the lender. They have to certify that if there has been a previous arrangement, a payment arrangement, and the borrower has defaulted in that for the first time, they've given the borrower 15 working days to make up the default. So if your client has a payment arrangement and they miss a payment, the lender's not allowed to raise a court action straight away. The Act provides that in the event of a first default, the lender must give the borrower 15 working days to make up the payment. If they make up the payment, they then can't raise the court action because they're not complying with the pre-action requirements. That provision only applies in respect of a first default, because you can imagine a situation where you have a borrower who defaults over and over again and then makes up the missed payment within the 15 working days. So that only applies in respect of the first default. So that may or may not be completed on the Form 11C. It would be a question of whether it's relevant to the circumstances of your case. The next pre-action requirement is that the borrower hasn't taken any steps which are likely to result in payment of the arrears. So that would be, for example, if your client has submitted a mortgage to rent application and clear evidence of that has been given to the borrower, and it's and it's likely that that application is going to be granted within a reasonable period of time. So the lender has to certify that that isn't the case. The next two pre-action requirements are fairly straightforward, and no information needs to be provided by the lender other than ticking the boxes. They have to certify that they have provided the borrower with information on sources of advice, and they also have to certify that they've encouraged the borrower to contact the local authority. Now, if the borrower doesn't get advice and if the borrower doesn't contact the local authority, that doesn't have any consequence as far as the lender is concerned. They simply have to certify that they have given that information and given that encouragement. Now, the last point I've put here isn't actually a pre-action requirement, but it has to be ticked off on the Form 11C. The lender has to confirm that in implementing the pre-action requirements, they've had regard to any guidance issued by the Scottish ministers. Now, guidance has already been issued, so that's something that you would need to be aware of when you're looking at whether pre-action requirements have been complied with. There are essentially three pieces of legislation and documentation which you should be looking at in relation to pre-action requirements. You've got the Act itself, which lists the pre-action requirements. There are then a set of regulations which expand on the pre-action requirements and give some more detail as to how the lender should implement those requirements, and then the guidance itself expands on it and gives some further guidance. So when you're looking at a Form 11C and when you're taking instructions as to whether the pre-action requirements have been complied with, then you should be aware of all those three pieces of legislation, regulations and guidance, and have regard to them when you're considering what the lender has done. Now, the initial court procedure is that all cases must call in court, and the hearing will be fixed when the initial writ is lodged by the lender. So what your client will get is a copy of the initial writ, the Form 11C, and they'll also get intimation of the hearing date. Now, that At the moment when an action is raised, the onus is on the borrower to take steps to prevent decree passing against him. He has to either lodge a notice of intention to defend or lodge a mortgage rights minute. So that's quite an important change, because it won't be a case of decree being granted automatically if the borrower doesn't respond to the initial writ. At the moment, if the borrower doesn't respond, the lender simply minutes for decree. He doesn't have to tell the borrower he's done that, and the court grants decree without intimating that to the borrower. They don't get another chance to oppose it. So it takes away any onus on the borrower to take steps to prevent decree passing automatically, and it means that the case will automatically call in court. Now, at the first hearing, even if the borrower doesn't attend the hearing, the sheriff doesn't automatically grant decree. The Act provides that the sheriff can only grant decree at the first hearing if he's satisfied that the pre-action requirements have been complied with and that it's reasonable to grant decree. So it's not going to be a case of, if the borrower doesn't attend court, the sheriff will just rubber stamp it and grant decree. The sheriff does have to make some inquiries. So he would have to be satisfied that the pre-action requirements have been complied with. So he'll have a look at the Form 11C, any evidence which has been produced, and if necessary, he can make inquiries with the lender's solicitor. But over and above that, he also has to be satisfied that it's reasonable for decree to be granted. I've seen a couple of cases at Edinburgh Sheriff Court recently where heritable cases have the same requirement for reasonableness to be established, even if those actions are not defended. In those two cases, which called in different days before different sheriffs, the defender didn't attend court, but the sheriff refused to grant decree because he wasn't satisfied it was reasonable. In both instances, the sheriff took the view that the level of arrears were too small to merit the defender losing their home. Now, it's the same sheriffs who are going to be hearing these cases, and it's the same test of reasonableness. So it shouldn't be a case that if the client doesn't attend court, decree will automatically be granted. There does have to be some consideration given by the sheriff. Now, obviously, it would be best for the borrower to either attend the hearing or to be represented, because then he can put his position to the court. He can oppose the application on a number of grounds. He can advise the court that the pre-action requirements haven't been complied with, and if that's his position, he would need to explain that to the court and give the lender's solicitor an opportunity to respond to that. Even if the pre-action requirements have been complied with, though, your client can still submit to the court that it's not reasonable to grant decree, and he can make representations to the court. So, for example, it may be that since the action was served on him, he's taken financial advice and he's perhaps submitted a mortgage to rent application. Now, if that's been done after the action was raised, it's not a breach of the pre-action requirements, but he has taken steps to repay the arrears. So it goes to the question of reasonableness as to whether or not the sheriff should grant decree. Now, at the hearing, the court requires to consider a number of factors, and the Act sets out 5 matters for the court to consider. 4 of them are identical to the matters which have to be considered in mortgage rights minutes, but one new matter has been added. So at the hearing, the sheriff has to look at the nature of and the reasons for the default. This is only if the borrower attends the hearing, though. So if your client is going to attend the hearing, or if you're representing the hearing, you should be prepared to address the sheriff on how the arrears came about, why they came about. The sheriff has to look at the ability of the borrower to fulfil the obligations within a reasonable period of time. So if your client has got any payment proposals to make, then that would need to be explained to the court. The sheriff has to look at any action taken by the creditor to assist the borrower. So there's a bit of an overlap there with the pre-action requirements, because in looking at those requirements, the court will look at what steps the lender has taken. The new factor is that the sheriff has to consider whether the borrower is participating in a debt payment programme. So if your client is taking part in the debt payment programme, then that needs to be mentioned to the court. And the final factor is that the court has to look at the ability of the debtor and any other residents in the property to secure reasonable alternative accommodation. So if your client has another property available to him which he could easily move into, then the sheriff has to have regard to that. If your client would be rendered homeless, though, then similarly the sheriff has to have regard to that. Now, this isn't an exhaustive list. The Act provides that the sheriff has to have regard to these factors in particular. It doesn't say that these are the only factors they have to look at. So anything else which is relevant to your client's case should be mentioned. So, for example, if your client has got health problems, that should be mentioned. That's something which we would always put in a mortgage rights minute. If there are young children in the family home, then that should be mentioned as well, the effect it's going to have on the children. So essentially anything which you think is relevant to the case should be put before the court at the first hearing, and the sheriff will take those matters into account. Insofar as further procedure is concerned, the sheriff has got a number of options available to him. The summary applications rules simply provide that a hearing will be fixed, and at the hearing the sheriff may order answers. There's no provision after that as to what the sheriff should or what he can do. It's similar to mortgage rights cases. If you lodge a mortgage rights minute in response to a calling up notice, that's done by summary application. So at the moment, the way those cases run is the sheriff will look at the circumstances of each case and will decide what's the best step to take. He'll be guided by what the lender's solicitor says and by what you say on your client's behalf. So if you're looking for a continuation, if for example you've just been instructed and you need more time to make inquiries, you can ask for a continuation. If your client's position is that he's concluded missives for the sale of the house, he can pay the amount in full within 6 weeks, you can ask for a 2-month continuation for that to be done. The sheriff may, after hearing what you've got to say on your client's behalf, if he feels it needs to be put down in writing, then he'll order answers to be lodged and he'll fix another hearing date after that. He may allow a period of time for adjustment, because if, for example, you're saying that the lender hasn't complied with the pre-action requirements and you're going to put that in your answers, the lender will want to respond to that. So the sheriff can allow a period of adjustment for the parties to change their written pleadings and to respond to what each other is saying. He can continue the action or he can put it on hold. So if a payment arrangement has been made since the action was raised, he could decide to put it on hold for 3 months, he could continue it for 3 months, really to give your client time to show that he can maintain that payment arrangement. He can fix an evidential hearing. If it's apparent that there are factual matters in dispute which evidence would need to be heard on, then he can fix an evidential hearing, which is likely to be a few months down the line. He can also grant decree or refuse the application at that stage. So if, for example, it is obvious at the first hearing that the pre-action requirements haven't been complied with, then the sheriff should be refusing the application at that point. Similarly, he may be satisfied that there's nothing to be said on your client's behalf which would make it unreasonable to grant decree, and he could decide to grant the decree at the first hearing. Now, the Act introduces the concept of entitled residence. You may have a client who is, for example, married to the borrower, but they're not a party to the action. The Act sets out the categories of entitled residence, and it centres around spouses or civil partners in certain circumstances. So if you have a client who isn't the borrower, what you would need to do is check the terms of Section 5 and see whether they are an entitled resident and whether they're entitled to make an application to the court. It doesn't include children, whether the children are under 16 or over 16. It does seem to centre around spouses and partners. Now, if the lender is aware of the entitled resident, the lender has to disclose that in the initial writ. There will be cases, though, where the lender just doesn't know there's an entitled resident living in the property, and in those cases it's up to the borrower to disclose that to the court. Whichever way the court becomes aware that there is an entitled resident, then the sheriff has to order that the initial writ be served on the entitled resident. So when the entitled resident gets the initial writ, they are then entitled to make an application to the court. There's a prescribed form for it. It's a Form 11E, and what they have to do is tick whatever box they fall into which makes them an entitled resident. They have to say what factors they want the court to consider, and they have to say what they want the court to do. So when the application is lodged, the sheriff will fix a hearing on it. You then get the application back and you have to intimate it to all the other parties in the case. And then at the first hearing, the sheriff has to have regard to the same matters he has to consider for the borrower. So that's the nature and reasons of the default, the ability of the entitled resident to pay their arrears within a reasonable period of time. It's the exact same factors, and the hearing will essentially run along on the basis of the first hearing for the borrower. The sheriff has got the same options open to him. He can grant a continuation, he can cease the action, he can fix an evidential hearing, he could decide to continue the case. Again, he'll be guided by the lender's solicitor and by you on your client's behalf. So it's really important to explain to the court what you want the sheriff to do in relation to the application. The Act also introduces procedure for minute for recall, and this is another quite important change. At the moment, if a client has a decree granted against them in a repossession action, that can only be recalled by lodging a reponing note at court, which is an application to recall the decree. Reponing note can only be done either by a solicitor or by the client themselves, and the sheriff has discretion as to whether or not to recall the decree. When you apply to court at the moment, you have to explain to the sheriff why your client didn't defend the action when it was first raised, and you have to explain what your client's position will be if they're allowed to defend the action now. The sheriff has discretion, and if he's not satisfied with the explanation given by your client, then he can refuse to recall the decree. We see reponing notes a lot, and practice varies between different sheriff courts, but it's not uncommon for applications to be refused. So the new procedure provides for a minute for recall. That's done by lodging a Form 11F. It's a prescribed form, and all you have to do is tick the box which your client falls into, which entitles them to apply for a minute for recall. You don't need to say why your client didn't defend the action, and you don't need to say what your client's position is going to be now. Now, when the application is lodged at court, the court will fix a hearing on it. You get your application back, and it has to be intimated to all the other parties, and you have to give them at least 7 days' notice of the hearing which has been fixed. Now, the Act provides that at that hearing, the sheriff must recall the decree. So the sheriff no longer has discretion in the matter. The decree has to be recalled. If the person who has applied for the recall doesn't attend court, they will get another chance. Because only 1 minute for recall can be done by each person, I imagine the courts will be reluctant to dismiss the minute for recall if the client or the person who has applied doesn't attend. So in that case, the sheriff will fix another hearing, which is called a peremptory diet. The person who's applied for the recall will be ordered to attend that hearing, and they would be advised that if they don't attend the next hearing, the matter will be dealt with in their absence. So the sheriff has to recall the decree, and then the hearing will go ahead as though it were the first hearing. So if you're applying on behalf of the borrower, it goes ahead as though it's the first hearing in relation to the borrower. If you're applying for the entitled resident, then it takes the place of the first hearing for the entitled resident, and the sheriff will go back and look at all the factors which we had spoken about. Now, only one application can be made by each party to the action, and the application can only be made if your client hasn't appeared, been represented or submitted an application previously. So it's quite different to heritable cases, which you may be more familiar with, where your client can go along and can attend court, but as long as they haven't stated a defence and if decree is granted, they can recall it. That's not the case here. If your client has appeared at any time or been represented or submitted an application, then they've entered the action and they're not allowed to do a minute for recall. Now, lay representation, from the point of view of court practice, the main point to note is that you have to be able to satisfy the sheriff throughout the proceedings that you are a suitable person to represent the borrower or entitled resident in that particular case. So it's not going to be the case that as soon as you are authorised to be a lay representative, you should be able to deal with every case and the sheriff will allow you to deal with every case. It is a question of satisfying the sheriff that you're able to deal with that particular case. Some cases will be more straightforward than others, and to meet this requirement, it's really going to be a question of knowing your capabilities and your competencies and assessing cases which are referred to you and deciding whether it's something that you're able to deal with or whether it's something which would be best to be passed on to another solicitor. When solicitors start appearing in court, we don't just start appearing in every case. We start off with the more straightforward cases, we start off with the more straightforward callings, so we'll go along to court when we know a case is agreed or where we know it's going to be continued. So I would urge lay representatives to do the same, to assess each case on its own merits and decide whether or not it's something which you feel you're able to deal with. I just wanted to make a few points about legal aid and expenses. It may be the case that your client is apparently eligible for legal aid and you would need to assess whether it's in their best interest for you to represent them or whether you should refer them on to a solicitor to apply for legal aid. Now, there are cases where, if, for example, your client has what's called a passport benefit, you would know straight away that he or she will be financially eligible for legal aid. In a lot of other cases, though, your client will have a contribution to pay, so a full financial assessment would need to be done by a solicitor, and the Legal Aid Board would assess whether contribution has to be paid. Now, even if your client doesn't have a contribution, or if they have a contribution and it's fixed at a set level, they may still have to pay other costs at a later date. The Scottish Legal Aid Board have clawback provisions, and if you have the benefit of an award of legal aid and you recover money or preserve property through a court action where you've used that legal aid, the board would be looking for your fees to be paid from that money or property. So, for example, if you have a case where a client is awarded legal aid but they're successful in the action, they get to keep their house and there's £40,000 of equity in the house, the Legal Aid Board would look at that and say, well, you've made a recovery or a preservation here of £40,000, so your client would be liable to make payment of their own fees. The main benefit of having an award of legal aid, other than your own costs being covered, is that it gives you some protection against being held liable for the other party's court expenses. The general rule is that if you lose a court action, the sheriff would expect you to pay the other side's costs. If you've got a legal aid certificate, you can ask the sheriff to modify your liability to nil, and 9 times out of 10 the sheriff will do that. So the benefit of having a legal aid certificate in a case like this is that if the lender's successful, you can ask the court to say you don't have to pay their court expenses. However, in this particular type of action, that protection is probably going to be academic, because the lender is entitled to add their costs on through the mortgage account. So even if you have a case where your client is not found liable for the court expenses, the lender, under the standard conditions which apply to the mortgage account, can still add their costs on in that way. So having an award of legal aid is perhaps not going to be as beneficial to a client in this type of case as it would be in other cases. The main thing to bear in mind is that if you have a client who's looking at opposing an application or making an order, or an entitled resident who wants to make an application, there will be cost implications, and that would have to be explained to them at the outset, and it would have to be borne in mind when they decide what they're going to do. Finally, I just wanted to make a few points about the transitional arrangements. As we've heard, any actions raised before the 30th of September 2010 will continue under the existing procedure. So mortgage rights minutes can still be lodged in respect of those cases, and if there's a mortgage rights minute already in process, then that procedure will continue. If a calling up notice has been served before the 30th of September but it hasn't expired yet, the lender doesn't need to raise a court action, and the voluntary surrender rules won't apply to that. But if they do raise a court action, then they have to raise it under the new procedure. Another important point to note is that you may have cases where the default has taken place before the 30th of September. So, for example, your client missed a mortgage payment in September, but the action isn't raised until December or January. Now, the pre-action requirement in relation to providing information on arrears, charges and costs provides that the information has to be provided as soon as reasonably practicable after the default. If the default occurred before the 30th of September, that provision is amended and the information simply has to be given as soon as reasonably practicable after the 30th of September. So the provision's not going to be retrospective. And then the final point is just in relation to minutes for recall. The new procedure for recall of decree can only be used in respect of decrees granted under the new procedure. It doesn't apply to decrees which are granted under actions which have already been raised. So if you have a client who comes in and decree's been granted against them, what you would have to do is to check when the action was raised and whether it was raised under the old procedure or the new procedure. Within the law service at Shelter, we still have clients coming in 2 and 3 years after decree's been granted, so there's going to be quite a long period of time where that will still have to be checked. If decree was granted in respect of an action raised under the old procedure, it can only be recalled by doing a reponing note, and the sheriff will still have discretion. If it was granted under the new procedure, then the minute for recall procedure which we've spoken about would apply. So I hope that's been helpful, and I would simply reiterate that it is all very new. Although it came into force a couple of days ago, we still haven't seen any cases under the new Act, and I imagine it may be some time before they start to filter through. So there are still some uncertainties as to how things will work in practice. Thank you.
Okay. Thanks very much, Eleanor. We're a wee bit behind time, but we've got about 5 minutes for any questions or any observations. And just to reiterate, a lot of the information, Form 11C and Form 11F, there's links to all of that stuff on the Keeping Your Home website, so don't feel that you have to mention guesswork there. But any questions, any observations? And if you can say who you are and where you're from. Take the gentleman at the back first, please.
Hello there, Legal Balance at the Council Advice Shop. Regarding to the court stage, I can't remember your name, but you mentioned the court costs of additional court hearings. Now, when it goes to the first stage, there's no charge for that. If it's continued at that stage, does that then go back to the first calling stage, or is that then a chargeable hearing in front of the sheriff?
No, there's no charge if there's simply a continuation after the first calling, a continuation to obtain further information, or a continuation to allow time for legal representation or something like that. There's no charge.
And that can go definitely at the sheriff's discretion then, really, how many times it can be continued then?
It's entirely at the sheriff's discretion how many times it be continued. It can be continued, and that's one of the things we're sort of worried about, that there'll be multiple continuations in cases which will lead to court rolls being congested with a lot of continued cases, and that would lead to delays in the court
Similar
system.
to the heritable court now?
So exactly the same.
Yeah. Okay, thank you.
Another question here, I think.
If you don't mind, sorry, Zara Strange from Aberdeen CAB. I've got two fairly short questions you might not be able to answer. The first is that, is there any procedure or what is expected to happen if the lay person is dismissed by the sheriff?
Well, if the lay person is dismissed by the sheriff, I think that would be pretty exceptional, really. But having said that, if the lay representative is making a complete horlicks of the case, then obviously the sheriff has the discretion to say, look, stop, and at that time the case would be continued to enable the defender to either obtain further lay representation, or a solicitor would come into the case.
Okay, so you'd expect it to be continued. Thank you.
Oh, it would certainly be continued. I mean, no sheriff would simply grant a decree because a lay representative.
No, I was thinking more in terms that they might expect the litigant to actually represent themselves.
Well, I think that's highly unlikely, unless the litigant wanted to represent themselves. If the litigant asks for more time to instruct either a solicitor or another lay representative, I can't see any sheriff refusing that.
Okay. The second point is that you say that it's up to the borrower to, under voluntary surrender, it's up to the borrower to notify of any entitled resident. Now, there are certainly we have cases in Aberdeen where people from other ethnic backgrounds have different opinions of the responsibility of entitled of their spouses. Now you say that there is, I mean, once that decision has been taken and the voluntary surrender has been signed off, that's it. There's no appeal, no recall, no nothing. Supposing that spouse has not been notified. Say, for example, they are non-English speaking, they're learning disabled, or the spouse may have a mental health issue. And that's not unknown with clients that we receive.
The onus is on the borrower when they are trying to arrange the voluntary surrender to ensure that all the relevant parties complete the certification which is required. It would be a case of, if you're advising somebody, the legislation quite clearly sets out who the relevant parties are, so it would be apparent as to, or it should be apparent to advisors whether or not there are other relevant parties who have to give that certification. My advice would be that if there is any doubt or any concern, it's something which shouldn't be done, and the lender would then simply have to raise a court action.
I'm going to ask you another question. I'm sure you can have conversation about that as well. Is there any other questions? We're on a bit of a time. Just one more here, I think then we'll probably stop at that. And I do apologise for the heat as well in here.
Rachel from Aberdeen. I just wanted to ask, do you have any feel yet for how courts are going to schedule these cases? Are they going to be, which court they're going to be scheduled in? Which cases they're going to call with? Is it going to be the Heritable Property Court or the Ordinary Cause Court or the debtors
it
court?
will vary, Rachel, in each individual sheriff court, but I would imagine that they will call on days where civil business is being conducted. As I say, each of the courts is unique in having their own court programme to suit local circumstances, but I would imagine they would call, I mean, if you speak to Fiona Henry in Aberdeen, she'll soon tell you, but I would imagine they would call on civil court days.
In Aberdeen, they're going to call in the Heritable Property Court. I just wondered if other courts were making different provisions.
Eleanor's probably going to
Yeah, different courts are making different arrangements. We've been in touch with quite a few of them. My understanding is that Dundee Sheriff Court has already fixed a timetable for their cases to call. Edinburgh, I think, initially had been planning on putting them in with the heritable cases on a Friday. They are now going to put them in different days throughout the week, but if they're on a Friday, they will be in the heritable court. And my understanding is that Glasgow are going to put them in during the week in one of the civil courts. So different courts appear to be adopting different practices.
Okay, I'm kind of conscious.